So again, hello everyone, and welcome to Judicial process. Today we are turning our focus from the actors of the judicial process, the judicial process work group, to the stages of adjudication, right? And what it looks like when a criminal trial, from beginning to end, looks like in the American justice system. So that being said, we actually start with pre-arrest procedures. And so the courts are involved prior to an arrest, but they are very limited in what they can do. All right, so again, this is online, don't write it all down, just take notes. To maintain the appearance of impartiality and the separation of powers, courts, like I said, they play a very, very limited role when it comes to before an arrest occurs. So when I say they play a very limited role, the rationale is the executive branch is the branch that's in charge of enforcing the law, right? So that's not just the president, but it also applies to the police, their executive agencies. So they are there to make the arrests, investigate crime, etc. And the courts shouldn't be involved, right? Shouldn't be in that process. Instead, the courts really act as this kind of neutral and detached check on law enforcement. All right, so the idea here is like if we just give police carte blanche to search, seize, arrest, do whatever they want to make an arrest or get a conviction, that's going to end up in abuse, right? We see this in developing nations and developed nations, where police departments have really just become overrun, and the government has a little control over them. So we want to prevent that. We prevent that with the courts. Now, the courts, again, are supposed to be neutral and detached, and their role is to actually protect the target, whoever the person that the police are going after, the target, they're there to protect their constitutional rights. Right? So they really do this in three ways. This check is asserted via a search warrant. We'll talk about it in a little bit. Charging decisions, which we'll talk about in a little bit. And issuance of arrest warrants. And so it's not that much involvement, but it is very important involvement when it comes to making sure that police don't step over the line. So this is just the Fourth Amendment of the Constitution, right? The relevant parts. The right of the people to be secure in their persons, houses, papers, and effects against reasonable searches and seizures shall not be violated, and no warrant shall issue but from probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So, we built that into the Constitution, was this check, right? And it's the Fourth Amendment. The Fourth Amendment says, look, law enforcement, if you want to go search someone, you got to go through the courts. You want to make an arrest, and there's exceptions to this, but generally speaking, you need an arrest warrant. You've got to go through the courts. And we really have this kind of prohibition on general warrants. So one thing that really ticked us off in our separation from England is England had general warrants and what were called writs of assistance. A general warrant was basically they gave law enforcement the power to search anyone at any time for any reason or no reason whatsoever. They could just come into your house. They had a general warrant. Writs of assistance, they could actually get other people in the community, other citizens, to come search your house with them. And so we were like, no, that's a bad idea. So that's where the Fourth Amendment derives from. And this idea of having a check on the police and making sure that we have a particularity requirement. So let's talk about a little bit about search and seizure law. All right, so the Fourth Amendment, again, it's going to maintain and it's going to protect mainly search and seizure activity. Now, what we're looking at is really for the Fourth Amendment, is we're looking to see if the police have intruded in a Fourth Amendment protected space, right? And there's the rationale that the Fourth Amendment protects people, not places. It protects anything that goes beyond the two-step requirements here, right? So we're looking at if police want to intrude upon a Fourth Amendment protected space, so a place where you have a reasonable expectation of privacy, where you would believe that the police would need a warrant, where they would need something to search you. The police have to demonstrate and get two things from the courts. First, the search has to be reasonable. Right? So the search has to be reasonable. If I'm looking for an unlicensed nuclear warhead, I'm not going to be able to check your sock drawer, right? Because those things are pretty friggin' big. Has to be reasonable. This extends to, where do I think you committed the crime? Do I think you were a drug dealer out of your home? What about your job? Should I be able to search McDonald's or wherever the hell you work? It has to be reasonable. The second thing they have to have is they must get prior authorization from a legally enforceable order, known as a warrant, from the courts upon the showing of probable cause. All right, so they have to show to the court, if it's a case of contraband, that they believe there's contraband at this particular location. They have to show that it's more likely than not that there's contraband at this particular location. Now, these hearings are conducted ex parte, so that means that the defendant is not invited. The defendant has no knowledge of any kind of search warrant proceedings, or the target at this point, I should say. And the rationale is, yeah, no shit. We don't want them to know, right? Like, if I'm going to come try to bust you for drugs, I don't want to tell you, hey, come to a search warrant hearing. We're going to talk about if we can come search your house for the drugs. Like, I'd be flushing that in a heartbeat, right? So again, it's done ex parte. But they have to show to the court probable cause. It's more likely than not that they're going to find contraband at this location. Or when we talk about arrest warrants, they have to show that one, it's more likely than not that a crime was committed, and two, it's more likely than not that you are the person who committed the crime. That's what we need to get a warrant. Now, I will say this. Warrants can be issued and still be unreasonable. So just because a court issues a warrant doesn't mean we can't say that search was unreasonable, right? Anything that kind of shocks the conscience, anything that goes way too far, we're going to say that's probably unreasonable. Right, so there's an interesting case. It's about basically it's a convenience store robbery, and the guy's armed, goes in the convenience store with a mask on, all that jazz, and he pulls out a gun, says, "Give me your money, give me all the cash out of the cash register." Well, the convenience store clerk had been robbed 5 times prior. It was really pissed off. And it was like, no, we're not doing this. So the convenience store clerk acts like he's going to the register, when in reality, he grabs a loaded cocked weapon real quick and shoots the robber. Right? Robber falls to the ground, robber gets up, robber runs. Police come, they send a bolo or be on the lookout to all local emergency rooms, right, saying, if somebody comes in with a gunshot wound, let us know, especially, if they're wearing dark clothing, if they're wearing whatever, let us know so we can come talk to them. Well, eventually they find that this guy goes to the emergency room, right, and the bullet is actually lodged between his heart and his lungs. And this is both pretty miraculous, and this kind of lodged in between them. Now, here's the problem. Police wanted to get the surgeon to go in, remove the bullet, so they had the bullet for evidence, because they didn't really have much else. They needed the bullet. Well, you think your body's pretty much a protected space, right? I don't think the government should be able to reach inside my body whenever they want. So we have an issue here of, do we need a warrant? Well, in this case, The police actually went to the judge to get a warrant and basically order that this guy undergo surgery and have the bullet removed so that they can prosecute him for robbing a convenience store. The judge in this case was like, you can go fuck yourself. Like, no. Like, and then the rationale was, you're going to put this person under general anesthesia, and general anesthesia is fatal for a number of people, right? So if you haven't ever been under anesthesia, I highly recommend it. It's really fun, but it's what the anesthesiologist is doing is he or she is bringing you as close to death as humanly possible, right? So your respiration slows down as close to death as humanly possible. Your heart slows to as close to death as humanly possible. It is, you are barely alive. You're walking a very fine edge. It's the reason anesthesiologists get paid a lot of money and also stays in the room the entire time and will stay with you when you recuperate and wake you up because they are constantly monitoring your heartbeat and they're adjusting medications and adjusting drugs to make sure that you don't die. But there are several people who do die, right? Every year they go to anesthesia, they either have an allergic reaction to the drugs that put them under, or the anesthesiologist goes a little bit too far and they're dead. So the argument here was, okay, what are you trying to prove? Is this a homicide? Is this a really severe crime? You want us to risk putting somebody, like killing somebody, so you get a bullet to prove that they tried to rob a convenience store? The judge wasn't having it. But hypothetically, if the judge did order that the bullet be removed, and the surgeon goes in and removes the bullet, and the guy lives, and then they arrest him, and he goes to trial. At trial, you could still argue that that search warrant is invalid because the search was unreasonable. Right? So you still keep that requirement that even if a court issues a warrant, you still have to be reasonable with the warrant. Right? So you can always come back and say, yes, they had a warrant, but it was an unreasonable warrant. So there are ways to fight warrants. Now, I talked about this a little bit about the Fourth Amendment and the idea that it provides this judicial oversight, largely because we were scared after we broke away from Britain, right? They had their criminal justice system at the time was just, for lack of better words, was out of control. I mean, obviously the king and authorized people to just basically do whatever the hell they wanted to do, and they could just search anyone for whatever reason or no reason. In fact, there was a judge who actually suppressed evidence. It was one of the first times that there was a suppression hearing in England, and said, no, this evidence can't come in because what you're doing is a violation of our basic human rights. And about a day later, miraculously, the king's police officers came and they just searched his house, the judge's house. Again, they had a general warrant. The judge didn't do anything wrong, he's following the law, but because he didn't agree with what the king said or the idea of general warrants, they searched him and they seized all of his writings and everything that they could imagine. Never got charged with anything, but they never gave it back. So that being said, we wanted this to be a system where we have a neutral party, right, that does not report to anyone. It does not matter to them issuing warrants to not issuing warrants, right? And our thought process is that it would be a fairly rare occurrence. Well, it turns out it's not a rare occurrence, right? So warrants are very much routinely issued. So there was an estimated, if we look at each state individually, most states don't keep records of how many search warrants they've issued. Maine does, and so this number is derived from Maine applied per capita by each state. So if we look, each year there are approximately 635,258 search warrants issued by the states, not even the feds, right? Doesn't include the feds. This is just the states. 600,000. Quite a bit. Considering there's only 50 states. So you imagine how many search warrants are issued a day in each state. Right? It starts to become kind of baffling. Well, keep in mind that judges at the state level, like we talked about, are generally elected. So they start telling the police no, they can't have search warrants. It's going to look bad on them when they go up for re-election. So it's very easy to get a search warrant. In fact, it's so easy that we have fill-in-the-blank forms published online. So if you look at Appendix D or Appendix D in your book, or you can select these links. Let's see if it still works. All right, so this is a searchable, or excuse me, fill-inable application for a search warrant. So you'll see this is at the federal level. There's a nice drop-down list. You just choose what district you're in. So you choose what district you're in. So we're going to say, go down to New York. We are in the Southern District. Let's go Southern. So what you do is you just type in exactly what you want, right? So who are you searching or what are you searching? So I'll search John Doe. Now here, it basically tells me, like, I have to say what property or what thing specifically I'm searching. And then I have to describe below my reasons for believing that there's a person concealed there, or there's evidence, or there's contraband, and I get to check box. I talk about what code it is, the offense description, and what facts I'm basing it on. I then sign it. I'm doing it under oath, right? And then it's done usually before the judge, and the judge signs it as well. So, sorry, all that crashed. So that's the application, all right? And it makes it easy on judges too, because not only do we publish the application online in a very easy to access format, we also make it easy for judges to issue these warrants, right? So if we look at Appendix D. This is a warrant. This should look really familiar, right? Like, it is almost exactly the same, it's got the same drop-down list, it has everything as, oh, as the search warrant authorization, or the application. Here you see this is a return. We'll talk a little bit later about what the return is, but you just see that the judge signs it, they put a date on it of when they have to do it before. Usually it's 14 days. When they can do it, at nighttime if they can, or they can do it in the daytime. Yeah, and they issue the warrant. Like I said, at the federal level, this is usually the magistrate judges, but this also can be district court judges, or even at the state level, right? This is where we're going to see most of the applications for search warrants and search warrants issues at the state level. States have very similar forms, right? So everything is for the most part, fill in the blank. All right. So basically what happens is after a preliminary judicial investigation, general oversight begins as soon as they fill out that application for the search warrant, right? Because they fill out the application, it has to be very specific about what they're going to search, who they're going to search, what section of the code are they violating. All that information has to be included. It also has to be included, and this is what's important, and this is a Fourth Amendment requirement, by an affidavit, right? So basically an affidavit is just a sworn statement. So when law enforcement signs the application for the search warrant, it usually accompanies with an affidavit, or the affidavit might be incorporated into the search warrant. When they sign that application, they're signing under the penalties of perjury, right? So if they are just making something up to get revenge on somebody, or they don't actually have the facts that they say they have, and it comes out in court this way, that officer individually can be imprisoned for perjury, right? So it is a really, really big deal. Now, once the magistrate gets the application, they have to consider the facts presented. So the application, like you saw in that section, lays out, tell us about what happened, tell us the facts, what's going on, we want to know more about the situation. So the magistrate considers the facts and the affidavit, and in a common sense manner, right? So basically a reasonable, rational, common sense manner, has to find that there is a fair probability that contraband or evidence of a crime will be found in a particular place. Right, fair probability, 50.01%, just slightly more likely than not. 50% and a feather. So it's a really, really low bar. Part of the explanation as to why warrants are issued so freely, because it's such a low bar. Keep in mind, when we go to trial, we have to prove that the person is guilty beyond a reasonable doubt, which is a very, very high bar. So, again, at this point, we're just searching, right? There's no arrest been made, probably. Sometimes there are, and things change a little bit. But usually the judge will just kind of take the warrant, sign it. I mean, it's just, law enforcement also prepares the warrant, because it's the exact same thing. And the judge just signs it, gives it to law enforcement, and they're good to go. Now, sometimes the judge is going to order an ex parte hearing, where they're going to examine the credibility of the evidence. So basically, law enforcement in the ex parte hearing has to come in and prove, right, that it's more likely than not that contraband or evidence of crime at some place. So this is really true when we have informants, like criminal informants, because they're kind of generally, we kind of perceive them as untrustworthy, right? Because that means they're doing criminal activity and we're letting them get away with it so long as they keep telling us information. If I'm a judge and all you have is an informant telling you what they saw, I don't want that informant in my courtroom. I want to be able to judge his or her credibility. I want to see their body language. I want to see how they talk. I want to see how they recall the information. So again, this is where judges, in their discretion, can order an ex parte hearing. It doesn't always happen. It's fairly rare. Usually the judge just signs off. Sometimes the judges don't even read it. They just sign it. Now, when we're applying for the search warrant, one thing that's very important, and this is true for the warrant itself, both will have to meet what's called the particularity requirement. Right? So, basically, particularity requirement means that you have to be very particular in your language as to where you're going to search, who you're going to search, what you're going to search for. Right? So any locations or objects that are not specifically listed in the search warrant may not be searched. All right, so this is a direct prohibition of general warrants under the British common rule. So again, let's say I get a search warrant for your house, but I tell the judge I'm looking for an unlicensed nuclear weapon. Those things are huge. In am I going to be able to, I have a search warrant for your house, am I going to be able to go through your drawers, your underwear drawer, your sock drawer, your whatever? No, because it's not going to fit in there. I can only search where the scope is reasonable. Now, that being said, law enforcement knows this. So what they do, and it's completely fair, is they are very, let's say they're searching for drugs, right? They are going to list every single thing that could possibly be related to drugs as possible. And they're going to want to go as small as possible, right? Like physically as small as possible item. Because now I can search a lot more places, right? If I was searching for the nuclear weapon, I can't go through your sock drawer. But suddenly if I'm searching for, and here's the list, cocaine, crack cocaine, marijuana, heroin, amphetamines, or derivatives thereof, packaging materials, so little tiny plastic bags, scales, and other devices used for the preparation, sale, and administration of said drugs in the United States currency, recording or monitoring devices used to facilitate the transaction of drugs, so on and so forth. It's a very long list, which you'll see in this. They're searching for drugs, that's really what they want, but they included anything for packaging. Well, that's those little tiny dime bags. Those things you can find anywhere, right? They can look through books, they can do whatever they want. They can look wherever they want for the most part, as long as it is within the scope of the wording of the search warrant. All right, so that's why particularity is so important. Is if they said, for the nuclear weapon example, we're looking for anything that could have been used to construct a nuclear weapon, any diaries or journals about nuclear weapons, suddenly we're getting small, right? And now I can start to search your drawers. Right? If I'm just looking for the one big thing, that's the only places I can look is where the big thing would be located. But if I suddenly have small things, I can search virtually anywhere. And let me tell you, search warrants are not pleasant experiences. We're going to watch the knock and announce in a minute, but law enforcement, they literally tear apart your place. I say literally, I mean like, they can cut holes into your couch cushions, your bed, you name it. They don't have to put anything back. Usually what they do is they check the bed, they search the bed area, and then they take everything in the house as they search it, and they dump it on the bed. And they just put it in one location because they know, all right, this is the things that we've already searched. So they'll empty your bookcases onto the bed after they search them. They'll empty every drawer onto the bed after they search it. Everything they look at is going to be piled on the bed until they find what they want to find. If they don't find anything, they just leave. Then you get to go put all that shit back, repair your front door probably. It's all on you, even if they didn't find it. Right? So again, they're not very pleasant experiences. They're very terrifying and horrible, but they're definitely good. So let's talk about executing the search warrant. So again, the search warrant is going to tell police officers the time in which they can execute the search warrant, the manner in which they can execute the search warrant, and the place where they can execute the search warrant, as well as any procedures that they have to employ during the search itself. Right, so if we look at the law, basically what has to happen is law enforcement has to comply with the federal rules of criminal procedure. Specifically, there's 3 things that they absolutely have to do. Right, these are kind of set in stone, and if you look at the sample warrants and the sample application for search warrant, you're going to see these indicated on there. So the first is all warrants have to be executed within 14 days of issuance. Otherwise, they are what's called stale and are invalid. Right? So that's why if you ever get served with a warrant, check the date. Because if it's past 14 days, you have an absolute right to throw them out of your house. Now, when you good luck doing it, you know, the men with the guns and pepper spray and stuff like that, like, good luck, but you theoretically can. Like 14 days, 2 weeks. So we're going to say, well, after 2 weeks, things change, right? Like, the drugs may have been moved, or this may have happened. We don't know. So we'll give you a 2-week window. Now, question, what happens if law enforcement, they get the warrant and they forget? It's day 15. What do they have to do? They got to go back and get a new warrant. And they get to explain to a very pissed off judge why they didn't execute the warrant in the original 14 days. And that judge has to generally find that it's a good excuse. If they don't have a good excuse, that judge is going to say, sorry, you had your chance. Right? Like, judges are very protective. Like, if you violate this rule, you have to have a really, really good reason, as in, well, 90% of our department came down with COVID and wasn't able to work. Okay, that's a decent excuse. But not, well, we accidentally left it on the copier, and then the intern found it. That judge is going to be like, no, screw you, you had your shot. Right? Because keep in mind, the judge is there to protect the rights of the individual. They're also going to be real pissed that you didn't follow their order, because that's what a warrant is. It's an order. Right? I command you to search, and you violated it. Now, generally speaking, warrants have to be executed during the daytime. We define daytime as the hours between 8 a.m. and 10 p.m. local time. Right, so wherever it is, 6 to 10. Why do we want warrants to be executed during the daytime? Thoughts? Is it because it's safer? Absolutely, it's safer, right? I mean, think about this. Like, you hear somebody down like stairs in the middle of your night, like fiddling with a lock or something like that, and you have a gun next to your bed. Like, you're going to grab that gun, you're going to go downstairs, and then they're going to be exchanging gunfire, right? Like, we don't want them doing it at night, right? It's not safe for the individual, and it's not safe for the officers. That being said, there are exceptions. So if you can prove to the judge that you have a very good reason for why you want to search at night, or why you want to conduct a search warrant at night, so after 10 p.m. or before 6 a.m., the judge can check the other box and say you can search at night. Now, this is only going to really occur when we know somebody's a dangerous person, right? We don't want them looking at their windows and seeing the police cars pull up and, people getting out and SWAT getting out and all that jazz, because then they're going to start loading that weapon. But if we conducted it at 3 in the morning, when we know that we do surveillance, we know that they're asleep, it's going to be a lot safer for us, because that person is going to see us driving up, they're not going to see us get out of the cars, they're not going to see us do all that jazz, right? And when they do a search, it's not subtle. Like, they'll bring like 8 or 9 police cars, SWAT truck, evidence truck, like it's not subtle. So in that case, if we can prove that the person is a dangerous person and that we need to do it at night to be the safest that we can do it, then the judge will allow it. And then we also require that post-search warrant, I showed you this a second ago, they give what's called a return, right? They give the return to the court. And what the return is basically a receipt. And they have to actually give a receipt to the person that they search. But a return is a receipt of the property that they've seized. Right? So it shows the court that 1, yes, we did execute the warrant at the time you told us to, and 2, this is what we found. And when I say like they have to be very specific, they have to record model numbers and serial numbers. They can't just say, oh, we seized a 27-inch Panasonic TV. No, it's a 27-inch Panasonic TV with 4K Ultra high def, serial number this, brand number this, USB number this. Like they just have to be that specific. Right? They give it to the court, it goes public record, but the person who they seize it from also gets a copy. And the idea, and this is true, is let's say that we seize your stuff and we think like, oh, we seize a canister of sugar or flour, and we think it's cocaine. And so we take it back to the lab, and the lab says, nope, It's flour. You get a phone call. Hi, you can come pick up your flour. And then you have to drive to the police station, the evidence laboratory, bring your receipt, your return, give it to them, and then they'll give you back your canister of flour. If it's contraband, you're not getting it back. Like, it's just not going to happen. But if it's something innocent or something that doesn't give us evidence and we're not going to use it in court, you get it back, but you have to have the receipt to get it back. So, if this video still works, let's look at the knock and announce rule. Okay, so really it's not going to play. There is an informal rule in the law that police officers have to do what's called knock and announce. Right? There are some times that they can go in, especially if it's dangerous, where they don't have to knock and announce. Like they can pick the lock and sneak in. But generally speaking, they have to knock and announce. And the idea is they have to knock, tell you who they are, what they're there for, and then give you time to come to the door and open it and let them in. Before they do what you see pictured here, which is breaking the fuck down. Now, the idea behind this is like, what if you're in the shower and the police are out, like the police just kind of come busting in and they're looking for like freaking marijuana or something small. And like they come into the shower, they're gonna pull back that shower curtain with guns on you, and you're gonna be butt naked, standing there like with your hands in the air until they deem that you're safe. And we're like, that's kind of humiliating. We don't want people to have to go through that. So we came up with a knock and announce rule. Now, in theory, there's a couple ways that we could do this, right? So a knock and announce could be a, hi, this is Dan of the Elmira City Police Department. We're here to execute a search warrant. Can you please open the door? That seems nice. That doesn't happen, right? The whole point of knock and announce, like police officers, like they're smart, right? They said, okay, we have to knock and announce. Let's make it an opportunity to scare the living shit out of whoever's on the other side of that door, right? Because we don't want them armed, or we don't want them doing whatever. Like we want them scared so that they don't try and hurt us. So we don't go, it's, usually we have like some battering ram or something along those lines, but we pound on the door, scream, police, search warrant, right, as loud as they can. That's it. They met the knock and announce rule. Now they have to wait a reasonable amount of time before they smash the door down. What is a reasonable amount of time? It's a really good question. It's a really, really good question. We don't have a set time, right? It's kind of based upon all the circumstances and things like that. So what often happens is you have boom, 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 police department, search warrant, 1, 2, 3, get the battering ram, break down the door. Right? I mean, like it's just bam, bam, bam. If they do wait a little longer, you go to open the door, as soon as that doorknob turns, they're kicking the door in. They're going to try to nail you with the door, make you fall back. The idea is, in case you're armed, it's going to get lost, whatever. They're going to spin you around as quick as possible. They're going to cuff you. They're going to do a protective sweep of the house, cuff anybody that's there. And then once everything is deemed secure and safe, then we kind of go through the process of we release these people who do not have to do this. Knock and announce rule, it's violated all the time. It does not mean that a warrant is suppressed or that the evidence is suppressed. So if police don't execute a warrant when they're supposed to, unless they have to prove good faith, we suppress the evidence. We say it can't come into play. But if they violate the knock and announce rule, that doesn't change anything. They had a valid warrant, they're doing it at the right time. They just didn't give you the opportunity to flush the drugs or to get out of the shower. We're not going to suppress the evidence. So that's the lovely knock and announce rule. So as I kind of alluded to earlier, once we get inside, we officers conduct what's called a protective sweep of the premises. And their goal is to, quote, gain control over anyone and anything that could pose a threat to the officers or the evidence during execution of the search warrant. So, what does this mean? This means everybody in the house is getting handcuffed. Everyone. This means that children, like we're talking 6-year-olds, will be in zip tie handcuffs face down on the floor with an officer having a gun pointed at their head until we deem that the location is safe. Now you can take that for what it is. You can agree with it, you can disagree with it, I don't care. Just know that that's what happens. Also, if you're going to commit crimes or you're going to be the subject of a search warrant, try not to have dogs. Officers don't think twice about shooting a dog that barks. Right, so if they bust down the door and they have like, it doesn't matter the size of the dog. Like if you have a German Shepherd coming at you like barking, they're going to shoot that German Shepherd and kill it because they don't want to get attacked. There's been a little controversy when they shot, oh, there was one in Georgia, there's two in Georgia. There's one where they shot a Chihuahua, which, one, is not a fucking dog, and two, like, just kick it. Like, it's a fucking Chihuahua. Like, it's not, under the book, I don't give a shit what you do with it. Like, fuck it. But there's another one where an old lady was sitting in a chair holding a dog, a small dog, a lap dog, and the dog started barking when the police came in. They shot the dog, missed, shot the old lady, killed her. They are not, police generally are not hesitant to use force during search warrants because they are very dangerous things. But it does lead to questions about how far should we allow it to go, how far is this reasonable. Ultimately, the old lady who was killed, her family sued the police department and won several $1 million from that. But if they just kill your dog, you're not getting any money. So if you love your dog, don't commit crimes. Yeah, because again, it's over anything or anyone. We do a protective sweep, we search the whole place, and then we decide from there, once we have control, we calm down a little bit, because the adrenaline kind of stops hitting us. We calm down, take some deep breaths, and then we decide what to do next steps. Now, as I mentioned before, if the search warrant is issued to locate contraband like narcotics, law enforcement may use deemed reasonable force. So this is just handcuffs, to detain the target or any occupants of the location when they are searching for contraband. All right, so if they're looking for narcotics, they can come in, they can detain, they can put everyone in that house in handcuffs and keep them in handcuffs. Reasonable force is also a sliding scale, so it depends on what kind of force you show to officers. All right, so they can use deadly force if it's reasonable under the circumstances. Even though you haven't been charged with a crime, they're just looking for evidence of the crime, you can still get shot. Right? So it is a very dangerous situation. Now they can detain anybody, target anybody at the scene. The idea is, if we let you go, we're saying, oh yeah, okay, you're safe. We're gonna search your house. I don't know, it takes about 6 hours. Come back in 6 hours and see where we're at. Well, if you have shit in your house, what are you gonna do? I don't know about you, my fat ass is gonna run. Like, I'm getting on the plane, I don't care. I'm not dealing with that. Like, if I know there's shit in my house. So that's why we say you can hold them there, right? Because if we find narcotics in the house, well, then we can just go from detaining them to arresting them right there. Right? We just leave the handcuffs on and then put them in the car. So it's really just when we go for contraband, nobody's coming, nobody's going. If, however, we are not looking for contraband, right? Or an individual is not an occupant of the location, we do a search. The people at the scene cannot be detained during the search. So we can do the protective sweep, we can put the cuffs on during the sweep, but then we have to pop the cuffs off as soon as we have control of the scene if we're not looking for contraband. We're just looking for evidence or looking for somebody who lives there, something along those lines. We cannot detain them. They are free to cut, they are free to go. They're also free to stay if they want. They can videotape officers doing the search if they want. They cannot interfere with the search in any way, but it's still your house, your property, you have a right to be there. Now there is a box that I asked you to look at, which was Sales Inc. versus New York. Basically this case, it was a obscenity case, if I recall correctly. It was an adult bookstore, and the police basically looked in places where they couldn't look. Search warrant filed an authorization to look in those places. They found evidence, and they got the arrest. The evidence ultimately gets thrown out, and it's what it is. Right. So again, officers have to really abide by the letter of the search warrant. Now there are such things as warrantless searches. These have been deemed per se, so they are deemed ab initio, they are deemed from the beginning, they are deemed absolutely unreasonable under the Fourth Amendment. All right, so you have to have the search warrant under the Fourth Amendment unless some exceptions apply. And these exceptions have been very well delineated. And they've actually come down from Katz v. United States and have trickled down from there. So we'll look at a few of them. These exceptions do provide law enforcement with a lot of latitude. Right? So the first thing is an investigatory stop, otherwise known as a Terry stop, or a stop and frisk. So this is where we don't have probable cause, but we have some kind of reasonable suspicion. As officers, we have some kind of reason to believe that you have committed a crime, you are committing a crime, or you're about to commit a crime. We can stop you, whether you're driving, whether you're walking down the street. We stop you, we can detain you. Generally speaking, we can pat you down, ask you some questions, and then we have to let you go. Right? That patting down, that's the search. Now, if it's a car, if you're driving, guess what? We can pat down the car. Like this isn't like we're just going down the outside, just touching it. We can basically look in the inside in any obvious places. So we don't need a warrant for that, right? This is usually like if we see something, we want them to be able to respond without having to get a warrant, then come back and the crime has occurred, or use ground, or something along those lines. We also have searches incident to a lawful arrest. So if we make an arrest of you, we can search anywhere in your immediate grabbable area. Right, so anywhere that, even if you're handcuffs, anywhere that you could theoretically lunge and get a weapon or destroy evidence or anything along those lines, we can search without a warrant. Let's say we're in your house. We can search anywhere in your immediate grabbable area. Can't search anywhere else, we don't have a warrant, but anywhere where you can grab, we can. Police officers are really smart. When it comes to searches incident to a lawful arrest, if you are in your vehicle, the police officer is generally going to handcuff you and have you sit against the hood of your vehicle. There's a reason for this. Because there's case law, and the case law says that if the police officer takes you away from your car, right, in your handcuffs, and puts you in the back of the police car, they cannot search your car. Because it's not your immediate grabbable area. Like, how are you going to get out of a locked car to go then run up to your car and grab a gun? You're not. But if we just have you sitting against the hood in handcuffs, we don't even have handcuffs. all the better. Then we're gonna be able to search your immediate grabbable area, and that's gonna be the entire car. All right, so it gives us an opportunity to search the car again without a search warrant. Seizure of things in plain view. So let's say I am searching, I think it's good. Let's say that I'm searching your house for drugs. And as I'm searching, I walk past, and I know it's like you're poor, like you just have shitty stuff. But I walk past this brand new stereo, gorgeous stereo, right? And I know that the local stereo store, it's still Best Buy, I guess, it's still a thing. They just had a burglary where somebody stole a stereo. And I happen to know the model number, I happen to know the serial number. But I can't see them. I have to turn the speaker upside, or the stereo upside down to see the serial number. Can I do that? No. Even though, like, I'm pretty damn sure this is the stolen space feature, I cannot manipulate anything to put it into plain view. All right, so no manipulation is allowed. But let's say that I walk in and I'm searching for, I don't know, like a child pornography is what I'm searching for. And I walk past your coffee table. On your coffee table is a big mound of white powder, and around it are little tiny dime bags filled with the white powder. Can I take those dime bags? Absolutely. Because if I immediately know, like, it is contraband, it is illegal, I don't have to do any manipulation to it. I know it's illegal, I can seize it, even though that's not what I'm looking for, because it's in plain sight. In the speaker case, I would have to call the judge and get a new warrant just for the stereo. Or they would say, they probably issue it, because yeah, it's probably stolen, probable cause, yeah. They would issue it, but I have to get a new warrant just for that stereo. Exigent circumstances. So this is, think about it this way. A felon is eluding police, right? And the felon runs down the street and runs into your home and slams the door right behind him. And the police are just chasing him. They come up to the door, they stop at the door. Do you want, in that case, where there's a dangerous felon in your home, do you want the police to have to call a judge and get a warrant and do ex parte hearing and before they go inside your house? Fuck no, you don't. Like, come on in. Exigent circumstances. Right? If it's an emergency situation where it's unrealistic, it's dangerous, unreliable to get a warrant, we'll allow police officers to go ahead and enter that house. Right? Because they're in hot pursuit, it's exigent, it's an emergency. It's part of how we justified the searches in Watertown, Massachusetts after the Boston Marathon bombing. Basically every house in Watertown, Massachusetts was searched by a warrant. There were animals killed during the searches because they didn't find them, but there were animals killed. But anything I see during that search, like, let's say a felon runs into your home and you're also a drug dealer, guess what? When police come in and they see the drugs, they can arrest you too. So, like, just hide your drugs, kids. Consent searches. If an officer ever, I'm going to say it, if you don't take anything else from this course, take this. If an officer ever asks, can I search your vehicle, or can I search your house, or can I search whatever, you fucking say no. No. No, 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 God damn it, no. Why? Because if a police officer is asking to search somewhere, they don't meet one of the exceptions and they don't have a warrant, so they can't search. Now, you might be thinking, well, I had clients that are just fucking dumb. There was one client, the officer came up and asked, Right? So this guy had a trunk full of heroin. Officer comes up and he goes, "Hi, can I search your vehicle?" They pulled him over for like a tail light, something like that. He's like, "Can I search your vehicle?" And my client goes, "Yeah, absolutely." And like when I met the client, I went, "Why?" Client said, "Well, I thought if I said yes, they would know I had nothing to hide and they wouldn't search." I'm like, that's basically like taking a kid to a fucking candy store, giving them $100 bill, and then being like, "You can't have any candy." Like, bullshit. Like, no. Now, the reason I say don't ever agree is if you have contraband, especially don't agree because you're going to get arrested. But don't agree because there are a few, not a majority, not even a lot, there are a few dirty cops. Cops do plant things. Again, back to the O.J. Simpson trial. Cops do plant things. So if they want to bust you for something, and it's a dirty cop, they're going to. If you didn't consent, they don't have that opportunity to find whatever it is they planted. Also, how many of you drive a used car? Raise your hand. I want to see it. Okay. Have you taken a look at your used car? Have you taken, let's say, the fabric off the roof, the lining of the trunk? Have you taken those off? Do you know who owned the car before you? What was a drug dealer? What was a member of what was out of your drug cartel? And they happened to put a bag of coke, right, in the trunk between the wall of the car and the liner. Guess what? Officer comes up. You don't have any contraband. Officer says, "Can I search your vehicle?" You say, "Absolutely." Guess what that officer is going to find? Because they are going to pull apart the lining of your car. They're going to find those drugs. And what are you going to say to the officer? "Those aren't mine. I didn't know they were there," because cops have never heard that before. Right? So again, never consent. Ever. Just never, ever. Just as a general rule, if a cop asks you, "Can I search?" say no. That being said, we'll pick up back here next class. We're going to look at the rest of warrantless searches, and we'll continue through the beginning stages of arrest, indictment, etc. If you have any questions, please always feel free to reach out to me. I'm here if you need me.